I thought, oh my gosh, that's just shocking.
Indeed.
All right. Okay, folks. So we've still got people joining. And yeah, like I said, to those of you who've joined you, like listened in on our little chat about the events of the weekend, because we're just giving you time to join the meeting. So good evening and welcome to Connect, the first one for 2024. My name is Wendy Lamarck here. I am the Registrar and Business Manager of QJA. Tonight's session is all about what's new. So there's been some recent changes both to Commonwealth Stat Decs and to the Justice of the Peace Act that are fairly significant for JPs, and it could change the way that we're witnessing. And I know a lot of you are thinking, is this the way of the future? Well, that's kind of yet to be decided. So we are recording tonight's session. And I'm just going to ask that if you have questions, if you could put them in the Q&A rather than in the chat. So we have quite a number of people registered for the webinar tonight, and we've currently got 50 odd in the webinar. So if the questions are put in chat, they can get lost in there. So if you could make sure that you put them in the Q&A. And yep, and then you're chatting away, so which is nice. So so welcome to you all from joining us from all over the state of Queensland. It's one of those things where technology means that we can do these things, and it's kind of been one of the better things to come out of COVID, is that we all learned to use Zoom or Teams for this kind of thing. So before we get going, I would like to acknowledge the traditional owners and custodians of the land from where we're joining this meeting tonight, their elders past, present and emerging. So my fellow panelists tonight are Sarah, who is on our board. And Sarah, you must forgive because she does have a bad case of the flu right now, so she's probably not going to say an awful lot. And John Carpendale. John is was QJO president for 2 terms, and has been serving on the as a director for as long as I've been working for QJA. So that must be over 10 years, John.
10 years, yep.
Yeah. And
no
of course
longer.
yeah, and not on the board anymore, but he's still very much involved, and he's the editor of the quarterly magazine and has written some wonderful articles in there, to do with JP practice. So I will hand over to John now.
Thank you, Wendy. Thank you very much. And thank you, everybody, for giving up this time on your Thursday night, when you could be doing something else much more exciting, I'm sure, to join us to hear a bit about what's new in 2024. So I've got a presentation, so I'm going to share my screen now, and hopefully this will work and you'll be able to see. All right, so can everybody see the screen? Wendy and Sarah, can you see it? Oh, yes? All good? Nod? Okay, thank you. Alrighty, so the title of the presentation is What's New in 2024. Okay, and I need to just move along. So the agenda for this evening, we're going to look at the new developments this year. We look at the purpose and objectives of the changes that have taken place, and then drill down a little bit to find out what exactly is different. And specifically the impacts for QJA members like yourself, a bit of a summary at the end, and finally, of course, there's any questions that you have, we'll be able to handle right at the end. Okay, so what is new this year? Well, as Wendy's alluded to, the amendments to the Commonwealth Statutory Declarations Act, which took effect from the 1st of January 2024. So that's just a little bit new. So we'll spend a bit of time looking at that and what the implications are for you guys. As well, amendments to the Queensland Justice of the Peace and Commissioners for Declarations Act 1991, which was approved by Parliament in 2023 and became effective from the 1st of April 2024. So it's only 18 days of effect that it's had for this particular piece of legislation. So we'll be looking at both those matters. Alrighty, so let's go to the Commonwealth Stat Decs and talk about what are the purposes and objectives of the changes. And we're going to, the source of this information is the July 2023 consultation paper on the proposal to reform the Stat Dec execution matters. So what did they say? Well, they said that it was to establish a framework that is fit for purpose and reflects the way that businesses and consumers want to engage and communicate digitally. It was also a response to the 2021 modernising document execution consultation process, which found that there was strong stakeholder support for the introduction of electronic and digital execution pathways, the Stat Decs, and that paper-based systems did not meet expectation of individuals of the small businesses and individuals and small businesses, and it was consuming considerable time and money in that particular process. So that was the formal explanation of as to why there was a change to the Commonwealth Stat Decs and the rationale that was used in the process of coming to that particular point when they were seeking consultation. So what is actually different from the 1st of July 2024? 1st of January. Now we have 3 execution options for Commonwealth Statutory Declarations. You're probably familiar with this. The fact is the traditional paper-based process that you're all very familiar with, wet ink signatures and in-person witnessing and so forth. Or there's also the electronic execution process, which means it can use electronic signatures, doesn't necessarily have to, but it can, and also audio-visual links processes. And finally, there is the digital execution process, which is end-to-end digital, and there's no witness involved in that particular process. So now we'll just go through each of those and talk about what is specifically is the impact for the QGAA members. Overall, the term there's no term witness in terms of the documents that are used for the Commonwealth. They used to be called the person before whom a declaration is made. And there's been a change. It's now called the person observing the declaration being made. So you're not called a witness on the Commonwealth Stat Dec, you are called an observer. Alrighty, so that's something that's changed. It's only a small change, but it's something that you need to be aware of. And the other thing you need to be aware of is that all people like yourself, all Queensland JPs and CDECs are actually persons who are authorised to observe, that is witness, a Commonwealth Stat Dec made either by paper-based or electronic execution options. So you are people who can do the whole box and dice of the first 2 options. Okay, so let's look at what are the impacts in relation to the paper-based execution process. And there's not a lot of change. There is a new Commonwealth Stat Dec form that was introduced. It's the difference between the old form and the new form is very, very minor. The old form, in fact, is still acceptable. So you don't need to force people to use a new form. If they bring along the old form, which is very difficult to tell the difference, it's still acceptable. Aside from that observer variation, what I just spoke about before, the other changes are at item 4, and that's in the notes on the side of the Commonwealth Stat Dec. The declarant must now insert their email address or telephone number. And in the previous version of the form, this was optional. And then similarly at item 10, the observer, that's yourself, the witness, must insert your email address or telephone number. That was previously optional. Of course, you can use the JP branch or QGAA address stamps, and they both include information which is complying in terms of both the address and the contact detail, either a phone number or an email address. So that can be used in order to satisfy that particular requirement. Okay, so let's look now at the electronic execution process. As I repeat, all people like yourself, all Queensland JPs and CDECs are authorised to do this automatically. Anybody who's a witness who can observe Commonwealth Stat Decs can do it electronically. And that includes the use of electronic signatures and video link technology. Of course, the Commonwealth Government has not given anybody very much information about how you're supposed to do that. And so you'll have noticed in Technical Bulletin 0124 from the JP branch, there is a little bit of guidance about that matter. So I'll just go through that very quickly, the matters that were in the technical bulletin, so that we refresh ourselves about what that is said. So electronic signatures, either wet ink or electronic signatures, may be used in the electronic execution option. So you don't have to use electronic signatures if you meet somebody on online using a video link process. People can sign wet ink and then scan the documents, and the witness yourself, you can also use wet ink signature and then scan the final document and exchange documents that way. But you can use either, and you are authorized to do so. If the witness elects to use the electronic signature, they may have a pasted image of a handwritten signature. That's one particular process that can be used. It's actually also possible to use, if there's a touchscreen on the tablet, smartphone, or laptop, to use a stylus or a finger to insert a signature, and both the declarant and the witness can do that. So somebody, if you're in a signing site, somebody could come along with their laptop with their statutory declaration on it, and you could take them through the process of, as you normally do in witnessing a stat dec, and then get to observe them insert their signature using the touchscreen. And then you could also add your details in the same way. It could be a little bit messy, but it's possible. This is possibly done, and it's something that is part of the process that is allowable as far as what the Commonwealth has got put in place. You can use an electronic signing platform like DocuSign, and if you want to be really sophisticated, you can use encryption and decryption technology with a public key infrastructure, but I don't think there'll be too many people who want to go down that particular path. But there's a range of options that you can use for electronic signatures, and if you have any questions, we'll talk about that later on. Okay, now let's talk about audio, video technology, the links. And again, this is information that's essentially in the technical bulletin. Freely available online platforms like Zoom that we're on now, Microsoft Teams, Skype, or similar, are all acceptable and they can be used. However, if you don't have computing equipment with a video link capability or enough knowledge to use about using video link technology, or the ability to conduct a video link meeting in a quiet location because of where you are, that's not possible if that's the situation. Or if you're doing it in your workplace and you don't have your employer's approval, or you don't really have knowledge about creating and using an electronic signature, or the software that you have on your computer that doesn't meet the needs for making audio and video link processes, then you have the right and should decline to witness electronically. So although you're authorized to do it, you're not bound to. If you're not happy with any of those things, you're not comfortable witnessing a document electronically, the Commonwealth Stat Dec, then although you're authorized to do it, you are not bound to use it to do it. And you can decline to do so if you don't feel comfortable. Now, what I'd like to do now is just look at a comparison of the electronic execution processes of both the Queensland Stat Dec and the Commonwealth Stat Dec. Okay, so who's authorised to witness? Queensland Stat Dec, only a few of you are special witnesses. So, whereas with the Commonwealth Stat Dec, all of you are authorised to witness a Commonwealth Stat Dec. So that's one area of differentiation. If you look at the form content, the Queensland form has got specific and substantial content that differentiates between a paper-based and an electronic execution process. The Commonwealth, there's no differentiation whatsoever. The receiving agency that receives that signed and witnessed statutory declaration will have no idea whether it was made physically or electronically, and that's by design with the Commonwealth. Now, we do recommend that QJA members who, if you are get involved in a Commonwealth Stat Dec and you do it electronically, that you might put a note in your logbook to indicate that that's what you've done. You're not bound to do that, but we think that would be good practice. Now, what I'd like to do now is just show you what I'm talking about in terms of the difference of the content of the forms. This is the Queensland form, pages 2, 3, and 4, and what's been circled are the areas of that form that are designed and dedicated specifically to differentiating between paper-based and electronic execution. Okay, so a substantial part of a 7-page form, and all these pages have got all this information plus pages of notes about electronic witnessing. So it's quite a substantial amount. Go to the Commonwealth form. This is the new Commonwealth form, and there's nothing in there. Nothing to indicate whether the form has been signed or witnessed physically or electronically, and there's no provision to make a differentiation on there. So you just complete the form in the normal way. Remembering, as I said before, at item 3, making sure the declarant inserts their contact details, either a telephone number or a email address, and the same thing at item 10 for the witness to do the same sort of thing. Okay, so final issue we'd look at is the digital execution process. Now, this is not going to worry you very much because there is no role at all for a JP or a CDEC in the digital execution process. What happens is the person uses something like MyGov and their MyGov digital ID to make their declaration online. It's an end-to-end digital process. We expect the volume of Commonwealth Stat Decs witnessed by yourselves physically or electronically even will gradually decrease as intending declarants become aware of this no witness option. And we expect it to become particularly popular with those individuals and businesses that are required to make regular statutory declarations as part of their normal work process. It's unlikely there'll be a lot of individuals who will go down the path of using that particular process because of the hoops you've got to go through in terms of using MyGov and the MyGov digital ID. If it's a one-off, it's probably not worth the problem. If you're going to be doing it regularly, you only need to do that once, and then you're away. And in future cases, it's all straightforward. Okay, so that's all I want to say at this stage about the Commonwealth Stat Dec changes, and I said we can answer any questions about that at the end of the session. Now I'd like to move along to the JP Act amendments and talk about, pardon me, the purpose and objectives of those changes. And the source for what I'm about to show you is the explanatory note and the second reading explanatory speech that was used for in Parliament for the amending legislation. Apparently, these changes were meant to enhance appointment, disqualification, and complaints procedures and conduct standards for JPs and CDECs. In addition, it was to remove those disqualification provisions which prevent suitable members of the community from being appointed due to minor offences. To introduce a more appropriate definition of what constitutes a disqualifying conviction and the provisions for managing that particular situation. To give legislative effect to the JP Code of JP CDEC, that should be CDEC, sorry, a typo there, Code of Conduct, and to enable continuous criminal history monitoring of appointed JPs and CDEC by the Queensland Police Service. So they were the sort of comments that were included in those documents about what the purpose and objectives of these changes were. As I said, they were introduced to Parliament and approved in Parliament 2023 and became effective from the 1st of April this year. Okay, so what is actually different? Well, there's a range of things. Okay, so section 15A now talks about an application for appointment. That's a new section. The qualification for appointment has been varied. There's some changes there. That's section 16. So there's amendments to that particular, and I'll talk about the details of this shortly. This is now regarding suitability is the matter that's being taken into account, and that's section 17 is now all about suitability. That's totally new in the new legislation. The term disqualifying conviction is a new term, and it's defined in section 17A. There are new suspension and revocation provisions in part 3 of the Act, which is a totally new part of the Act. So I'll talk a little bit about the detail of that as well for your information. As I said before, the Code of Conduct is now included in the legislation. That's section 31G, gives effect to that. And then section 33 has been amended to have new monitoring and reporting of criminal history processes. So let's go through these each one at a time. Application for appointment, that's section 15A. Has to be an approved form now. Although the previous legislation didn't mention that, there always was an approved form. It's just, you know, the legislation mentions that. The chief executive is now empowered to determine if the applicant is qualified. This is new. Previously, it was all seemed to be in the hands of the minister. So this is something that's new. If the applicant has a disqualifying conviction, and we'll talk about the definition of that shortly, they can apply for an exemption under section 17B. So although at face value, they've got a conviction that might disqualify them, there is provision for the applicant to apply to have that exemption set up, to have that conviction set aside for the sake of being appointed, and that's new in section 17B. The chief executive is empowered to decide an exemption application, and again, this is new. If the chief executive approves, the minister must recommend appointment. And if the chief executive rejects the application, the applicant must be informed has an option to seek a QCAT review of the decision, and that is new. So previously there was no review process. Now there is the chief executive gets involved, and if you are unhappy with the decision of the chief executive, you can seek a review to the to QCAT if you think it's not fair and proper. Okay, qualification for appointment. This is section 16, which I say has been varied. The applicant is qualified if the chief executive is satisfied that the person is suitable. And there's a definition in the next slide about what suitability means. However, a person is not qualified if they're insolvent under administration. That's not new. That was the same under the previous processes. Has a disqualifying conviction, and we'll define that in a later slide. So we'll talk about exactly what that means. If their previous appointment was revoked in the previous 5 years, so that's something new that wasn't in the previous legislation. So that's a ground for which you can be not qualified. Now, I want to draw to your attention the fact that the specific numbers of road traffic convictions are no longer automatic disqualification triggers. But you should be aware that those convictions may still be included in suitability determinations, which we'll talk about now in the next slide. Okay, so this section of 7E is all about suitability. In the previous legislation, there was no concept of suitability in terms of legislation, but in actual fact, when you made an application to be appointed as a JP, you had to jump through some hoops to demonstrate that you were suitable, but the legislation was silent on that particular aspect of it. In determining a person's suitability for appointment or continuing to hold office, the chief executive may consider the character and standing of the person in the community, any occupational license suspension, revocation, or disqualification. So if a person held an occupational license and they had some issues, irregularities in relation to that, that can be taken into account in determining whether they're suitable to be appointed. Similarly, the number and circumstances of any offence convictions. Now, whereas the driving offences are no longer part of the disqualification, automatic disqualification process, they are not totally ignored. So any offence convictions you have, the number and circumstances of those can be taken into account in determining whether or not you're suitable. So just because the driving offences have been taken out of the disqualification process doesn't mean we can all drive like hoons and hooligans. Because if in fact there is it's reported to the JP branch that an individual, has 20 or 30 driving infringements each year, it may be that the decision, the chief executive may come to think that the person isn't a suitable person to continue to hold office. So although it's not automatic, those sorts of things can still be taken into account in determining suitability. And for a person already appointed, this only applies to a person already appointed. The number and circumstances of any breaches of the prescribed code of conduct can also be taken into account to determine suitability. All right. disqualifying convictions. And this is sections 17A and 17B. So this is a new term, disqualifying conviction, and it's defined as a conviction, including a spent conviction for an indictable offence, an offence involving dishonesty. Now, indictable offence was one of the previous ones that was disqualified. Dishonesty is a new one. Breach of confidentiality is also a new one. However, I need to draw to your attention that confidentiality is mentioned in the Act, in the new Act, in the amended Act, but it's defined in a way that it applies only to people who are employed in the public sector and who are administering the operation of the JP system. So the employees of the Justice of the Peace Branch, they have special expectations about confidentiality. So if they were to leak information about us to somebody they shouldn't, then they may be disqualified from holding office as a JP or a CDEC because of that. Similarly, people in the in the police department, if they were providing information about convictions and they were again sharing it in a way that they shouldn't have been, then they could also be involved. So this particular breach of confidentiality is not something that that applies to anybody who's not employed in that particular way, although confidentiality is mentioned in the Code of Conduct, so it can be taken into account in terms of suitability to be appointed, but not disqualifying. An offence against the JP Act, that's not new. That was under the old provisions. A conviction, including a spent conviction for an offence which has a sentence of imprisonment, even if the sentence was suspended. Again, that is new. So that's a further extension of the definition of what's a disqualifying conviction. Now, Section 17B, as I mentioned before, provides for applications for exemption in relation to Section 17A conviction. So if an individual does happen to have a conviction that's defined under Section 17A, then that individual, if they wish to continue with their application or if they wish to continue to be hold office, they do have the opportunity to make an application for exemption if they think there are special circumstances that warrants that, and that needs to be considered by the Chief Executive. Suspension. Now, this is Section 17C. Under the previous legislation, there was no concept of suspension mentioned. If somebody was in office or their appointment was revoked, there was no provision to suspend them in any way, shape, or form. So this is something that's new. An appointment may be suspended if the Chief Executive believes there is ground for revoking appointment or considers a revocation investigation is warranted. So this is like a preliminary process to stand the person aside and suspend them whilst they work out whether or not their appointment should be revoked by an investigation or whatever. So that's what the suspension process is about. Now, if the appointee has been charged with these offences, so like an indictable offence, but hasn't been convicted, they can also be suspended. An offence involving dishonesty, offence involving a breach of confidentiality, offence against the JP Act, or they've not complied with the Chief Executive's directions to undertake an approved training course, then they can be suspended until those matters are determined, whether or not the person's going to be, their appointment's going to be revoked or whether they're going to be allowed to continue in office. All right, so revocation of appointment. This is the final one. This is where the person's appointment is dismissed and they're revoked and they lose their office. So the minister may recommend that occur if the Chief Executive is satisfied. So the Chief Executive does get involved. So the Chief Executive really is like the person, the head of the Justice Department. They're the Chief Executive in terms of the Act. The person is no longer a suitable person to hold appointments. So we talked about suitability before. That's Section 17. If they've had serious or repeated contraventions of the Code of Conduct, that's a new one that can be a cause for revocation. And I'm aware that having discussed things with the JP branch people before, that there have been a very small number of individuals who are had been in this particular situation, had been repeatedly and seriously not complying with the code of conduct, and under the previous legislation, the JP branch had no power to do anything about that. So this is new, and they need to. It has to be pretty serious, and it has to be repeated. But there is provision for that to occur. If the person no longer qualifies for appointment, which we talked about under section 16, or if the person has a disqualifying conviction, then under those situations, their appointment can be revoked. Now, code of conduct, as I said before, it's now taken into account for can be taken into account for suspension and for revocation. There was no code of conduct mentioned in the previous legislation, although, as we all know, the handbook, whether it's a JP or a CDEC handbook, includes a copy of the code of conduct. Contraventions of the code may now be considered for both suitability and revocation determinations. It's now embedded in the Act, and I spoke about that before. Now, there's been a new code proclaimed. Now, the new code, I've compared the old code and the new code, and the variations between the two are very, very difficult to find, but there is just a couple. The number of items in the old code, the new code are identical, but the previous clause 11, which talked about the Bible being used for a Christian oath, I think that was fairly self-evident, has been deleted. So that's no longer part of the code of conduct. A new clause 3 has been inserted. JPs and CDECs shall at all times perform their functions honestly, fairly, competently, and diligently. I don't think there's anything very controversial there. I think we'd probably all agree with that. As a result of those two changes, there's been some minor renumbering of the other items with clauses within the code, but by and large, the content of the new code, which has been proclaimed and as part of the Act, is very, very similar and almost identical to the previous code of conduct that we're all familiar with, and that we probably read each night before we go to bed so that we know about it, or perhaps we're suffering from insomnia, and it's very helpful in that particular regard. Okay, now criminal history reporting. Section 33. Previously, the Commissioner of Police was required to give a report to the JP branch on a person's criminal history only when asked to do so by the Chief Executive. So in practice, that meant that for appointed JPs and CDECs like ourselves, the JP branch was really only aware of any criminal charges and convictions if the appointee self-disclosed. So if you had breaches of, you had some contraventions, if you exceeded the number of driving offences you were supposed to, and you didn't tell the JP branch about it, they had a very difficult time trying to work out whether to find out that it actually happened, because the police office wasn't automatically reporting it, and if you didn't self-disclose it, they would hardly know about it. But most people are so honest and upfront that I'm sure they did that. But now the Commissioner under Section 33 is expected to notify if any appointee, that's like ourselves, is charged with or convicted of an offence. And so the result is ongoing and continuous monitoring and reporting of appointee charges and convictions. All right, so what's the impact for QJA members? Well, there are people who are currently disqualified with the prescribed number of driving offences no longer being the trigger for disqualification. We actually have people, including QJA members, who were previously disqualified because of traffic convictions, who'll now be eligible for appointment or reappointment. So that's a good thing, because the driving convictions, everybody agreed, wasn't a small number of driving convictions that could easily be exceeded, was not a good measure of whether a person was a suitable person for appointment for holding office. And so that's been dispensed with. And in addition to that, the people who were previously disqualified for that are now eligible for appointment or reappointment. Previously, only the Minister had the power to grant exemption for a disqualification situation. Now the Chief Executive has the power to do that. If they're disqualified, and if the person applies for a exemption and that's rejected, they may seek a QCAT review, which I think is a good, important thing. In terms of suitability, your character, community standing, occupational license, indiscretions, etc., those things there that are highlighted are matters of which can take into account for suitability. Should the chief executive consider you no longer suitable for office, your appointment will be suspended while investigation is undertaken, but you'll be given notice of action and advised of what's happening in relation to that particular matter. Revocation determinations. Again, we've mentioned these things before: suitable person, serious code of conduct breaches, seeking to be qualified, disqualifying convictions, etc. The chief executive is satisfied that one or more of those apply to you. The minister may recommend that your appointment be revoked. However, before revocation action is considered or recommended, you must be given the opportunity to show cause why it should not proceed. So there's an opportunity for that to occur. So that's a good thing. All right, so what are the impacts of disqualifying exemption from a disqualification conviction? Should you be convicted of an offence that is regarded as a disqualifying conviction, you have the opportunity to apply to be exempt from that, which is stopping you from holding office or being appointed to holding office. We've talked about this before. The chief executive may grant the exemption if it's considered it would be appropriate in special circumstances, and if that chief executive rejects it, you have a QCAT review process. Now, this is the final impact is about the fact that you're a member of the QJA. Okay, so should you be advised that suspension or revocation of your appointment is being considered, or that you've incurred a disqualifying conviction from which you wish to apply for exemption, or your application for exemption is rejected and you wish to seek a QCAT review of that decision. As a QJA member, you're entitled to the support of your association preparing information to respond to those particular circumstances. So QJA is there to support you and assist you if you happen to find yourself in those particular unfortunate situations. So being a member of the QJA is of a strong advantage in relation to those matters. So summarising. In essence, these amendments to the JP Act were intended to enable the JP branch to reinforce behaviour standards expected of appointees and to more appropriately identify, manage and deal with the rare unsatisfactory behaviour incidents within the JP CDEC ranks. For the vast majority of us, the changes are entirely consistent with the behaviour standards we expect from ourselves and fellow JP CDECs and contain nothing about which we should be concerned. And finally, of course, Technical Bulletin 0224 had a very brief summary of these changes, but nothing like the detail that I've gone into tonight. So that's the end of my presentation. I now will open it up for questions and ask, I guess, Wendy and Sarah to find. So will I stop sharing?
Yeah, probably a good idea. Thanks, John.
Okay.
Yeah. Just on the Commonwealth Stat Decks, I think that kind of raises the digital witnessing kind of elephant in the room type thing. You're a special witness and you have been since I kind of first started. So what's it like, witnessing, say, a statutory declaration online? Do you find that you're more than comfortable with using Zoom, and do you use digital signatures or do you apply wet signatures? How do you do it?
Yeah, so I generally apply digital signatures. So yeah, I haven't actually been involved from the start. I wasn't in the first batch, but when they extended a little bit, I got involved. So yes, I've been doing it for a couple of years now, and I would get 4 or 5 cases a week, I guess, of people who contact me to have documents. I got a lot of repeat cases of people, businesses that have to do statutory declarations and affidavits as a part of their business process. That once they make a contact, once they continue to come back to the same individual. And yeah, so I use Zoom, schedule a meeting. Person contacts me and indicates that they'd like to do it. So I get them to tell me to text me their email address, and I set up a Zoom meeting at a time that's convenient to both parties. And shoot that to them. Get online. I see the form, see their ID, take them through the process of warnings and declarations or oaths and affidavits, affirmations, and watch them, witness them, observe them, attach their signature, and many people are doing that electronically. Some people go back to tilt the screen so I can see them sign it on wet ink. Then they then scan the document and send it to me, and I generally do all my process electronically. I use Adobe
Okay. Yep.
sign and so forth, and so I just add some notes that we're required to add if necessary. The new stat dec form has all the notes in it, but if not, if it's
Yep.
the old stat dec form, we've got to add a whole stack of notes about being a special witness and so forth.
Yeah.
Used to
Yeah.
do that for the Commonwealth form. Don't have to do that. The new Commonwealth form, you just treat it the same as you do if you were doing it face to face. So it's much more streamlined. So anyhow, that's
Okay.
in essence, that's the process that I use for electronic. Digital, I haven't had an experience with at all. I mean, yeah, so the digital process the Commonwealth is talking about is where the witness is not involved. So it's the person goes online and uses MyGov and MyGov ID and does it all. It's a bit like individuals can do traffic infringement statutory declarations with the
Yeah. That's right.
the portal, but so many people have difficulty doing that they most of them still come along face to face
Yeah.
to get it done because they just get so frustrated with the
Yeah.
technology
It depends on the technology and
yep,
availability of the technology and having internet and all those
yep,
kind of things that
yep,
have to line neatly up, I
yep,
suppose. So
yep,
and just on the changes to the JP Act, it talks
yep.
about the chief executive a lot.
Mm-hmm.
And so the question comes up, who is the chief executive?
Yep.
And rightfully, the chief executive is the Director General of the Department of Justice and Attorney General.
Yep.
And that is a lady called Yasmina Yoldik.
Mm-hmm.
But I understand that in practical terms, a
Yep.
lot of those duties will be delegated to Damien Mealy as the Director and Registrar of the JP branch, because
I have no doubt.
it's doubtful the Director General is going to be as intimately across knowledge of practice and what
Yep.
JPs do, and
Yep.
so
Exactly.
effectively it's Damien.
Yep. But probably in some cases, if it's going to go to
yeah,
the minister,
yeah,
I'm sure Damien will take it to the DG
yeah.
for approval before it goes
It'll
to. He might be
it'll get
communicating directly with the
some
minister.
vetting, no
Yeah.
doubt, and
But most of the work,
yeah,
you're right, will be done in the
yeah.
JP branch. Yeah, exactly.
Yeah, so
Yep.
it's sort of a watch this space thing in terms of suspension, investigation, revocation of appointment,
Absolutely. Yeah. I mean,
and
we shouldn't be thinking that everybody's going to
no,
get caught up in this.
that there's going to be a deluge. You certainly hope not, but it
Yep.
would be if we did have a member who needed some assistance along
Yep.
those lines,
Yep.
then probably the first thing that we would ask is some kind of written permission to talk to JP Branch, because
Yep.
otherwise we'll hit the privacy brick wall. So
Yeah, I mean, yeah. So I mean, we'll as an association, we'll do everything we can to
yeah,
help our members.
yeah,
If
certainly,
if the member is done more than we can help them with in terms of contravening what should be done, then although we support them, we can't make any guarantees that that's going to make any difference. But some people might not be too proficient in terms of putting together documents to support their cases for things, and that's something that I think the association can and should be supported. And also, if there is an opportunity to, if negotiations and discussions are taking place, then an individual may wish to have a QJA member come along with them from the QJA. When I say QJA member, a representative of QJA, to support them in any discussions and processes they might have. So, yeah, I mean, it's a bit like a union, sort of thing, to try and give the person some support and assistance in if they're going through a difficult process. So it's going to be difficult for whoever might be involved.
Yeah, certainly, and it certainly sort of puts a new definition of what advocacy might mean for our organisation. So, just a couple of questions. Greg Zeith has asked, with a Commonwealth Stat Dec, if there's a list of who can be an observer, not just JPs, it's the same list that's on
It
this
is
on the
exactly.
Commonwealth Stat. It's a huge list.
There's 50
Yeah,
more than 50 categories. So
yeah,
if you're a
professional
teacher,
occupations. Yeah,
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 a
yeah.
teacher,
It's
a pharmacist, a dentist, a postal clerk, and so it goes on and on and on.
an
So
accountant, an
all those,
engineer,
yep,
chemist, a
exactly.
vet.
So
Uh,
all those people can do it, and they've been able
yeah.
to do ordinary stat decks, and so they can also do electronic signatures. So it's not just, it's more likely that QJA members who are skilled and experienced in properly administering and processing statutory declarations will be people that should be doing it, but
Mm,
there'll be no vetting by the Commonwealth government about this. It'll be open slather. So if
true.
if you get asked, if somebody rings you and says, I understand that I've got a Commonwealth Stat Dec, I understand that you're a JP and therefore you're able to do that. Well, the answer is yes. Will you want to do it? Well, if it was me, I don't mind because
Yeah,
I'm experienced with doing it. I've got no problems with it. It took me a while to get my head around the process, but now I have. It's second nature.
yeah, right.
If I can imagine that quite a few of our members will be reluctant, and that's understandable. And you're not bound to, although you're authorised to do it. There's no
Mm,
compulsion. If you are not comfortable with using video technologies and electronic signatures and that sort of stuff, well, just say, look, I'm sorry, this is not for me. You'll have to find somebody else. And if that's the case, should just say they look at the directory for people who can witness the special witnesses like myself who can do the Queensland Stat Decs who won't knock anybody back because they'll, if as
mm.
long as they're available, they're happy to do it.
Yeah, true.
Okay.
And Margaret Peel is asking if does being declared bankrupt make one unsuitable for holding office? Uh,
You've got to
I think
be
it talks about
insolvent under administration. Now, what the
yeah,
definition of that is?
undischarged, I think is the
Yeah,
term, is it not?
yeah.
So yeah,
Yeah, well,
um,
the Act talks about insolvent under administration. So,
yeah,
whatever the technical term, and I don't know the answer to that question,
yeah,
but if somebody was, we could find that out if somebody was in a
yeah,
situation where they had that particular thing as to what exactly that meant.
yeah,
So if
yeah,
somebody is concerned about it, then we would certainly be happy to find out exactly what the answer to that question is.
yeah.
But off the top of
My
my head, I
guess would
don't
be
know.
if you were undischarged, so you still
Yeah, they
because as I
used to use
understand
that
it,
term, but the
yeah.
new legislation doesn't use undischarged that
Oh,
term. So I don't
okay.
know. I don't
That's
know
like
whether that makes any difference.
yeah,
I think if it's under administration, that probably means it's undischarged because it's still under
yeah.
administration. So it hasn't been
And
settled.
sort of the
I
person has
think,
to kind of
but I'm
report
not an
and
expert on that. So
yeah,
yeah,
I'd say
if
that's
we
what it
need
means.
to, we probably need to work that out and get so we can answer that question properly for that person. Yep.
Yeah, yeah, yeah.
Okay.
Tommy Lay is asking, out of curiosity, do we know what personal information the JP branch will be providing QPS as part of this new legislation? I think I can answer that, John, because we
Yep.
asked JP branch about this just a few days ago. It's the way that continual monitoring is going to work and the permission behind it is going to be in the new application forms. So everyone who's from the 1st of April, everyone who applies after that, somewhere in that form, they're giving permission for JP Branch to do that. When a lot of us completed the same application forms, we would have given permission for JP Branch to check our traffic history, our criminal history, electoral rolls, all that sort of stuff.
Yep.
And so there's still a little bit of a grey area as to whether permission that, say, I gave back in 2002 is still relevant today. So that's
Okay. Yep.
something. So it's sort of going to come in for people that are appointed from the 1st of April because it will be almost automatic. And but for everyone else, it's still something that they're going to have to backtrack on in terms of that information. So I think it's really a name and date of birth type match between databases. So
Yep. Anyhow.
and somehow it'll be. I'm not sure how it will how it's going to
No.
work in
Anyhow,
practical terms.
we can
So
keep people informed if once we
yeah,
find out more about that little detail. Yep.
yeah, yeah. And JP Branch will get that one sorted out. They've got to kind
Yep.
of address all the legal privacy issues that
Mhm.
might be related to that.
Yep.
And Pamela is asking, if you're currently a suspended person and are now eligible for reappointment, do you need to redo the approved training course? I think when you're
No.
suspended, they haven't
So
revoked you yet.
no, you're not
Yeah.
suspended. You can't be suspended under the old legislation. There was no suspension
Okay.
provision. So
Currently. Yeah.
yeah. No, well, the new legislation's in, so it's there now. But
Okay.
previously, if somebody was in a situation where they were disqualified, and that came to the attention of the JP branch, they were disqualified. The old legislation didn't just, it was like black and white. Either you're good or you're gone. But if there was a likelihood that it was because of traffic infringements which were going to expire shortly, etc., in terms of the time limit, then there was an informal approach where the person had to be deregistered temporarily, but when they satisfied the circumstances, and they're now satisfied with the new legislation anyhow,
Mm.
they reappoint them and give them the same number. So there was an informal process that was in place, but there was no, they couldn't do suspension. So now there's a suspension process which allows investigations to occur and for people not to be actually not to lose their number and not to be
Yeah.
actually disqualified while they go through a process and work out, how bad is this, and
Yeah.
et cetera, et cetera.
Mm.
So
Although
so
it's
nobody's actually, some people might think they're suspended now, but technically they're not. They're
yeah.
disqualified at the present time, but they
Yeah.
can become requalified now, depending on
Right.
if it's a traffic infringement thing. Yeah.
Yeah. Yeah. And
Well,
if they haven't already been appointed, then it will depend on the currency of their
oh,
statement of
that's
attainment.
exactly. Yeah,
Yeah.
that's
So
correct. Yeah, you're right.
yeah.
Yes, yes. Yep.
It's conceivable though that, if I was, and again, we're kind of, this is like just hypotheticals. If
Mhm.
someone was suspended, because of, maybe something in the code of conduct, or, because they believe that their competency as a JP was called into question,
Yep.
it's conceivable that they might say to that person, you need to go and do some training,
Yep.
and, or retraining.
Yep. Indeed.
And I
And
think
there's
that's sort of
provision for
something
that.
that,
Yeah. So
yeah,
so
yeah,
and
that,
if they decline to do that, they can
yeah,
be disqualified.
yeah, they
If
might
they
just say you need to go and, just go
Yep.
and
Yep.
refresh your, because you haven't
Yep.
done, because there's kind of implied in the code of conduct that you keep your skills up to date.
Absolutely.
So,
Yep.
so it might be that, they find that, this person has to go and do some professional development, and that might be where QJA can fill a gap as well. I mean, we already do it. So,
Yep.
it's
True.
it's possible that that might happen. But I think if you're suspended through this process, it's like you haven't been revoked yet, so you don't have to reapply for appointment per se. So, it's only when you got revoked, yeah,
Yep.
and then even then, and it's sort of that that exemption for the disqualifying conviction. Kind of the intention behind that is that, if for example, someone did something stupid when they were young,
Yep.
and
Yeah.
that's
So
probably a few of you online.
technically it's
So,
disqualifying,
but
but
you did
it's
something
so
so
long
stupid
ago that
that you
the yes. Yep.
got a conviction, when you were 18,
Yep.
that you might say, well, yeah, I've got this conviction, but I was young and stupid back then,
Yep.
and I'm
Yep.
40 years on, I'm a much better person now.
Indeed. Yep.
So that it's kind of, that's what the intention is
Yep.
behind that
Yep.
applying for exemption thing.
Yep.
So,
So I think that
mm,
some of those sorts of changes are fairer, that they give
yeah,
processes for both suspension and for appeals, and for show cause arrangements. So it's a fair process, and there's those processes that will allow QJA to become involved and support their members if they happen to find themselves in those
mm,
situations as well. Yep.
yeah. We have another question
Hmm.
from an anonymous attendee that says, in other
Okay.
states and territories, the cost to register as a JP and to undertake training is paid for by the respective state or territory government. Do we know why Queensland doesn't do this?
Well, Queensland isn't the only state that has a process that it costs a person to become involved. But there are certainly are some jurisdictions where there is more support than there is for Queensland. And Wendy will know that she and I when I was president. I spent some time talking to the then Attorney General, who's now the Minister for Health, and about a process to try and minimise the cost that people had to pay to become JPs. We got a compromise in that it's been agreed that those people who are not working, who are retirees or who are students, etc., will be given some sort of concession discount, but they were concerned about it being open slather, and for those people whose businesses were actually supporting them to paying them to become JPs, not getting that done without a cost of and supposedly the cost the JP branch charges is the cost that they incur in doing the research and so forth they need to do in order to vet an application. Whether that's true or not, I don't know. But there is some obviously some rationale in that particular approach. So yeah, there is true that there is some differences between jurisdictions, but there's lots of differences between jurisdictions as well as what happens with the way JPs are processed and so forth. Yep.
Yeah, it's sort of having to do a qualification for appointment, which is something that the chief executive now can decide. It used to be the minister. That came out of the Fitzgerald inquiry in 1991 to say that, look, some of the documents that you're dealing with are pretty significant. And so if you're going to be appointed, especially if you're appointed for life, then you should know you need to have some competencies around that. And then that kind of led to, in order for the standards to be consistent, it led to it being a accredited course with ASQA as nationally recognised course. So the reason why there's a cost to training is that what you're actually paying for is a qualification. Excuse me.
Yeah, it's okay. So yeah, that's true. So Wendy, I did mention before, but I'll happy to provide a copy of my presentation. So I'll send you a PDF. I'll correct that typo, and Sarah's got her hand up. She's going to ask a question. Can't
you're on mute.
You muted, Sarah. You are muted.
I said you caught my cough, Wendy.
Yeah.
Just a quick one, John.
Yes,
just to
Sarah.
reiterate, I heard in your talk that if someone presents and wants to witness a stat dec under the Christian oath, that you no longer need to produce a Bible for them.
No, that's not the case. The code of conduct just reinforced that. That's all. There was a clause in the code of conduct which said that. The handbook will still say that that's the way of doing it. It won't be part of the code of conduct. Okay, so it's only it's been removed from the code of conduct. That's all. So it's not as though you don't have to do it anymore. It's just the code of conduct doesn't contain that clause. So you're still supposed to use the Christian Bible when somebody wants to make an oath, and I think everybody knows that. And I think they felt it was unnecessary to have that particular clause in there.
Okay, thank you.
Okay.
Thank you.
And just before we wrap up, we do have a couple of people with their hands up. Are you still?
Sure.
Daniel, you've had your hand up for a while. Are you still wanting to talk? Okay.
Daniel's muted at the present time.
Yeah. And Brandon Hooper, Leanne Kendall, and Bruce Betwell.
Okay.
So I've made you panelists, so you're able to talk. If you want to take yourself off mute, go ahead. If you accidentally raised your hand,
you can take it down.
You can lower it.
Okay. Well, Daniel's done that. Leanne's done that. Bruce has still got his hand up.
Bruce, you still have your hand raised. So if you take yourself off mute, you can. Excuse me. No? Okay.
Oh, he's taking it.
Yeah.
Alrighty.
So that kind of wraps it up for this evening, folks. Thank you very much to John, who's always very wise and knowledgeable about these things.
Thank you.
Especially the I think the Commonwealth Stat Deck. I read that technical rules for about 4 times and I was still confused. I think it's because they just tried to put everything in it, and yeah, it just sort of you went what? Yeah. So thank you very much for clarifying that, and your explanation of the changes to the JP Act, and of course for taking the time to present on our QJA Connect. So thank you very much for that. Thank you to everyone who attended. We have been recording this session, so we will send through a link to the recording once it's sort of uploaded into YouTube, as always. And John, you kindly offered to provide your PowerPoints as well, which is great. So, and Bruce still has his hand raised. Bruce? No.
Hi, Bruce.
Okay. All right. So we're going to wrap it up. Thank you to everyone who's attended.
Thank you, Sarah.
Yeah, and thank you, Sarah. Stay tuned for our next Connect. We don't know what that's going to be at this stage, but we will decide, and just, a bit of an advert. The conference is on the 1st of June, and it's getting very, very close to fully booked. I think we only have a couple of places left for the conference itself and for the dinner and the welcome function. So if you're wanting to attend, get in soon, because we will be closing the registrations because we're just going to be so booked. And Daylene Ray has raised her hand. Daylene, are you wanting to talk? No. Okay. Oh, sorry, Daylene, go ahead.
No, I do not. Sorry.
Oh.
I don't know how I raised it, and I don't know how to put it down.
It's okay.
It's down now.
It's all right. We're finishing up anyway. So yes, the conference on the 1st of June. This weekend there are 2 workshops on. There's one in Redlands, and we're going to be revisiting the Commonwealth Stat Decks there too. And there is a workshop in Logan. I think they're covering off advanced care planning. So that's in Logan at the Logan Rec Club, and the Redlands one is in Indigenous Gates. So that is on Saturday. Mackay is running a workshop on Saturday also. I think they have, I think they're covering off sort of things like production notices, and I think Brendan Ballock from JP Branch is attending that, as is Sarah. So hopefully you're feeling better by then, Sarah. So there's a few things going on. So stay tuned, and we hope to be in touch, and thank you very much for attending Connect tonight, and we will send through the recording. So thank you to my panelists and to you, the audience. Cheers and good night.
Not everybody.